seated. Thank you.
Mr. Martin, did you have an opportunity to review the motions?
I have.
All right. Argument?
Who wants to assist motion?
Judge, I'm going to rely obviously on my memorandum concerning the law, but let me give the court a little bit of background, I think a little bit of foundation why we think this is important. As the court knows, with Officer or Deputy Jalop, Corporal Jalop back then at the Sheriff's Office, when she transferred over to the GPD, we felt that that was enough separation not to ask for this particular type of process of an adverse party. However, certainly all the majority of the officers that are going to be testifying in this case work for Sheriff Nacco. The court remembers when this case first came up, Sheriff Nacco had, I believe, multiple press conferences voicing his opinion as to why he had arrested Mr. Reeves, what evidence he thought was the factual basis for the arrest of Mr. Reeves. And even as of late as of yesterday, and I made my statement here that I believe that the investigation in this particular case was flawed. If you read the article from Channel 13, you will see that he responded immediately. He must be watching live stream this particular hearing, but he responded immediately, and his statement was, and I'm going to read it for the court. His statement was, "It's disappointing that the defense attorney is discrediting the professionalism of our outstanding members to deflect attention from the legal issue at hand." And so as you can see, he is making that statement to all of his officers that are employed below him. And so all of my reasons for wanting to make the officers adverse parties, I think, dovetail into these particular foundations. It is very, very common, as the court knows, when there's an officer that's part of the investigative team, the prosecution team, that the courts often allow the defense attorneys to use leading questions and do, in fact, find that the officers are an adverse party. These officers are associated, obviously, with Sheriff Nacco. He employs them, and he is going to probably be watching their testimony here because, obviously, he was very quick to comment yesterday on my statement.
Response?
First motion I'd like to deal with, Judge, is the motion to declare the police officers as a hostile witness. Let me direct your attention to the pleading itself. Motion to designate Anthony Bassone and each and every listed witness employed by the Pasco County Sheriff's Office as a witness identified with an adverse party under 90.6123 and to allow the defense to interrogate each of them with leading questions. If you would go to page 2 of 4, the first paragraph reads, after the amendments were implemented, once a witness is identified with an adverse party, leading questions are automatically permitted during direct examination. And he quotes Earhart, page 728. Earhart at page 728 states, Section 90.612, paren 3 provides that a hostile witness may be examined with leading questions on direct examination since they are necessary. Hostility is determined at the time the witness testifies and is not presumed. That's not in his motion. This isn't automatic. It is not presumed. Now, let me talk about the cases that were cited by the defense. They have to show that there's a relationship in which there would be a situation where the party would have an interest in not cooperating with the examination by the attorney. One of the examples that Earhart points out is when a defendant police officer that his attorney wants to call fellow officers of that defendant police attorney, of that defendant police officer, former police officer. And the court suggested that that relationship was a relationship that was close enough where they could be declared to be hostile. Now, what we have here, Judge, is we have Mr. Reeves. He has no relationship with the Pasco County Sheriff's Office. None of the officers are former officers of the Pasco County Sheriff's Office. This is not a civil case. This is a criminal case. This is a case where you have police officers that have written reports. This is a case where we have police officers that have been deposed ad nauseum for days at times. They are locked into everything that they're going to say in the deposition. Mr. Escobar has that. He can question them. If they divert from the deposition and they don't have a reasonable explanation as to why they're diverting from the deposition, then they'll probably impeach by their deposition. So there's tools and safeguards out there that are at the disposal of Mr. Escobar. You can't presume that the police officers are going to come in and testify just because Mr. Escobar asks the questions as opposed to me asking the questions. It cannot be presumed. So he cannot establish a relationship automatically. Now, during the course of the examination, if things take place where it's apparent to the court that the officers are not forthwith like they would be with any other person asking them questions, then maybe at that time is when it's right to have this inquiry to determine whether or not they're going to be declared hostile witnesses. But we can't presume automatically that they're hostile just because they work for the sheriff's office. So that's the first part. The second...
May I respond to that one since we keep them apart, because Mr. Michaels is going to be arguing the one on Ms. Olson.
Are you going to take the second part with Ms. Olson?
Yes, but however the court wants to proceed, I'm
Go
easy.
ahead, Mr.
Judge,
Rogers.
I assume that Mr. Martin is just confused concerning this particular section, because what he failed to do is to read the next sentence. At no point in time in my motion do you see the word hostility. My motion says adverse party. And so let me read to you the next sentence in Earhart that he failed to read to you, and I'm sure that that was just inadvertent on his part. The next sentence says, leading questions may be used during direct examination of an adverse party. An inherent incentive exists in an adverse party to provide self-serving testimony by avoiding the question or slanting the answer. Section 90.612(3) also provides that leading questions can be used during the direct examination of a witness identified with an adverse party, being a former or present employee, a coworker, a relative, or having a romantic interest in an adverse party, is sufficient to find that a witness is identified with the adverse party, and leading questions are automatically permitted during the direct examination. So too an officer, director, or managing agent of a public or private corporation, or a partnership, or association who is an adverse party, are witnesses identified with an adverse party under this particular section. So he's mixing apples and oranges. This is not hostility. This is merely an adverse party, which is proper under the rule.
All the cases cited by defense counsel deals with civil cases where you do have, quote, adverse parties. That's why I started out, this is a criminal case. And we cannot presume that the police officers are going to testify any differently depending on who they're called. And again, I point out that, as Mr. Escobar tried to already point out to the court, Officer Gillette testified. He didn't declare her a hostile witness. He said, oh, the separation is there. She's a police officer listed by the state. I find that somewhat disingenuous argument, because he says this police officer is okay, but this one's not. When we go back and look at the cases that are cited, one of the cases that's cited is where the prosecutor is allowed to lead a friend of the defendant who also participated in the crime. Well, that's not what we have here. We don't have officers who participated in the crime and are equally culpable for the actions of Mr. Reeves. So the cases that have been cited are not on point where you have officers who just conducted an investigation to be automatically declared adverse parties pursuant to that rule so that leading questions can be asked. So I would suggest to the court that we are talking apples and oranges as far as the federal cases that have been cited. And in this particular case, we do not have what the rules contemplated as an adverse party in a criminal case when the defense elects to call, in their case, officers who investigated the crime. That is not what the rule anticipated, and you cannot presume that they're going to act any differently if they were called by either party. I don't have anything else, Judge. I think you've read the cases, you've read Earhart.
All right.
It is what it is.
The only question left in my mind is, as to Mr. Martin's argument is correct, everybody has been deposed. Does that have any bearing on
I don't believe, Your Honor. I think the whole premise for adverse party is that so that the litigants can have a free-flowing, smooth presentation of the evidence. And because of the fact that these officers do have an interest, and they have a boss that's looking over this case with a magnifying glass, that puts us in a predicament where, we're not going to have a free-flowing information unless we are allowed to lead. Obviously, these are experienced officers. If I ask a leading question and that leading question is not correct, they're going to be, well-versed to be able to say, no, Mr. Escobar, that's not correct. Let me tell you what it is. But we've never had, in 34 years of my practice, I've never had a problem, calling a police officer an adverse party and have this sort of litigation, because it's very common in litigation, criminal, civil, wherever it is. It's part of the reason that the rules have been formulated is to allow that free flow of presentation.
Judge, I've been practicing for 34 years too. This is the first time I've ever had a defense attorney file a motion to declare a police officer adverse. So no, it's not prevalent. It doesn't happen all the time. It might be Mr. Escobar's way of doing things, but no, it's not. And you've had police officers testify in your court over and over, called by the defense. They testify, it happens. So no, this isn't automatic. This isn't just, this is the way it always happened and always should be done. You cannot presume that they're going to testify any differently. I think and if I could humbly suggest to the court, respectfully suggest to the court wait to see how the flow goes. If it's like Mr. Escobar says, where they're dodging the question, they're being evasive, and then I think that's the time for maybe the court to make a determination, but it can't be presumed in this case.
I just want to remind the court of what I just read from Channel 13. I mean, that is loud and clear to every officer in Pasco County from their boss. And this is a very, very serious trial where I've got someone's life in my hands. And we can't just take chances and say, well, let's see how it goes. This is a very, very serious matter. I think the sheriff, did it for us yesterday when he made that particular statement. I think he's put, the pressure that he wants to exert on his officers, and I think it's unfair.
All right. There's no question that typically law enforcement is called by the state as witnesses. This type of hearing is, as we all know, kind of does a flip side with the burden on the defense. So the defense is the one calling the witnesses in this case. And I also have the ultimate authority to regulate the examination of witnesses. So in an abundance of caution and in order to just move this along, I'm going to grant the defense's motions. There's no question that because of the adversarial nature of our justice system, the law enforcement officers' interests are certainly typically at odds with that of the defendant. I don't think I'm misstating anything there. And in the case of Mrs. Olson, there's clearly been an identification with the prosecution in this instance, and not surprisingly so. So I'm going to grant defense's motions on that.
Thank you, Your Honor.
Let's see, we have Mr. Quinlan, Zephyr Hills High School students here. Welcome, everybody. Who's your first witness?
Defense calls Nicole Olson. Good morning, Ms. Olson.
Good morning, sir.
Please state your name for the court reporter, spelling your first and your last name.
Nicole Olson, O-U-L-S-O-N.
Let's talk about January 13th of 2014, okay?
Yes,
On that day, you went to the theater with Mr. Olson.
yes,
You went to the Cobb Theater in Wesley Chapel.
yes,
You went to see Lone Survivor for a matinee showing.
correct.
You got there early,
Yes,
and you sat in the upper section.
yes,
You sat one row from the very back row of seats,
that's correct.
somewhere towards the middle.
Yes,
And when you got there, it wasn't very busy.
not at all.
You were one of the early ones to arrive.
Correct.
There was a gentleman sitting in front of you by himself,
Yes,
and he had a brief conversation with Mr. Olson,
a friendly conversation, yes.
innocuous about movies or something like that.
That's correct.
A very friendly conversation. Is that yes? for the court
Yes.
reporter? Thank you. Now,
Your Honor, if we could just have her push her mic just so that that'd be great. Thank you, Ms. Olson.
now, at some point, Mr. Olson was on his telephone during that early period,
Yes,
and you weren't involved with that, except he showed it to you briefly, a joker of some sort.
correct.
And at some point, Mr. Olson gets up to go back to the refreshment stand to get some additional snacks, some Twizzlers.
Yes,
Before that, on the way in, you got some popcorn and a Coca-Cola,
on our initial entrance after buying the tickets, yes.
right, when you first got in. And I left that out. Now, in terms of when Mr. Olson came back from getting the Twizzlers, there was something on the screen, but you don't remember what was playing.
Correct.
You had a discussion, or you didn't have a discussion, you don't remember whether you discussed anything with him at that point.
The only discussion we had that I recall at that point was with the gentleman in front of us and over the phone that he showed me before, some items we were joking and laughing at.
When Mr. Olson gets back, he has his Twizzlers, you don't know whether or not he was also holding his phone.
No,
At some point, because you were sharing the popcorn, Mr. Olson finishes some of the popcorn and hands you a bag with some of the popcorn left.
yes,
And that popcorn you put to your left side on the floor eventually.
down by my purse, yes.
I'm sorry?
Down to my left by my purse, yes.
And I didn't say this before, but when you were in the theater, as you faced the screen, Mr. Olson was to your right.
Correct.
Now, right around that time, or close in time to that, you pick up the armrest
I can't say that, no.
and you snuggle with Mr. Olson.
I cannot say that at that specific time I picked up the armrest, no.
At some point, you pick up the armrest and you cuddle with him.
The armrest could have been moved throughout the time that we were there, yes.
Okay? So do you remember lifting up the armrest?
I can't recall, no.
Okay. You remember taking a deposition?
Yes,
Okay, let me show you something. Now, I say deposition as if you know what that means. You know what a deposition is?
Yes, I do.
All right. And you remember taking that right here in this building
Yes,
on Monday, June 15th
yes,
of 2015?
okay.
Your Honor, I'm going to ask for a page.
And I'll give him the
before-
page and
yeah.
line as soon as I get there.
Your Honor, I'm going to ask for a page number before he begins his questioning and allow me time to read it so I can put it in contact before he asks the questions because I may have an objection.
I know Mr. Martin didn't hear me. As soon as I get to that page and number, I will give it to him.
Correct.
Thank you. Okay, it's page 125, lines 12 through 16. I'll give Mr. Martin a chance to look at that. Actually, we'll start on line 10. It puts it more in context. Question, you had a cup holder.
Is there any objection?
Yes. There is an objection. I recall her statement, and I read her depo. I do not believe it's inconsistent, and I also object to the manner in which we're attempting to use the depo, because first you give the witness an opportunity to read the deposition where he wants it, then you ask, having read the deposition, do you recall this and this happened? Yes, we can't use the deposition as, quote, substantive evidence and to start reading it into the deposition. That is the proper way, and to attempt to use the deposition to either refresh or impeach, because right now, this is not inconsistent with her testimony. It's worded a little bit different, but it's not inconsistent, and that's the trouble you have with just reading page after page of deposition. So I believe that is the proper procedure. Allow her to read it, you then re-ask the question, is that what you said? Yes, and then if she says, no, that's not, then you can read the deposition in the record. That is the proper way to do it.
Judge, I disagree with that tutorial. If I were to attempt to refresh a witness's recollection, then I would tend to agree with Mr. Martin. However, in terms of impeaching, certainly I'm not introducing evidence, as Mr. Martin knows and the court knows. The information that is published in the process of impeachment is for the court's consideration as to whether or not the individual is being truthful. It has nothing, we're not introducing that statement as truth, and I think Mr. Martin knows that, so if I may proceed.
Hang on. The key to the impeachment is substantially inconsistent. I'm not privy to
Yes.
the depo, so I don't, and that's often a point of contention. What one person thinks is substantially inconsistent is often not what I think is substantially inconsistent. So I'll need to see myself before I find that it's proper impeachment. Somebody show me. Well, you can read it. It doesn't work, it's me. I'm gonna either hear it or see it.
Okay.
So
Question,
typically, we would have a jury, so, but we don't.
question, you had a cup holder on your left. Answer, yeah, I believe they're on every aisle. Question, but you had raised one of them between you and him? Answer, at some point, yes. I can't promise it wasn't down to begin with when we were eating, but when we snuggled, I would have lifted it up, yeah.
she doesn't remember the time she did it. She didn't say it didn't happen. She just can't put it in sequence. And that's the nitpicky part of when you're trying to use a deposition, it has to be
Substantially
exactly.
inconsistent. I'm gonna,
Judge, but I don't agree with the characterization. I don't believe her answer was that, I don't remember at which point. I believe I asked her at any point if she lifted up, and I believe her answer was that she didn't remember.
well, in there, she indicated she didn't know if it was up to begin with. So it wouldn't be completely inconsistent if she said she didn't lift it up. I'm gonna sustain the objection.
Okay. At some point, the armrest between you and Mr. Olson was up, right?
It wouldn't be unusual throughout any movie we go to for it to be up or down, depending on what we were doing at the time.
And I understand, Ms. Olson, and believe me when I tell you that I'm not here to nitpick or harass you, but it's important to be able to understand even some of the details. So please bear with me. At that particular movie, at some point, was the armrest up, and were you snuggling with Mr. Olson?
Yes.
Okay, thank you. Now, at some point, Mr. Olson gets back on his phone.
Correct.
And we can agree that you don't know if he was texting or looking through the internet. You don't know what he was doing because you weren't paying attention to that.
Correct.
And while that's going on, and we're taking it step by step, there's something playing on the screen, but we can agree you don't remember what was playing on the screen.
That's correct.
Now, at some point close in time to that, somebody sits behind you, right? A couple sits behind you.
Yes, I don't recall seeing them come in or specifically sit behind me, but yes,
Okay.
they did end up there.
And you know that because at some point, you were leaning against your husband and watching the screen when somebody said something from the row behind you.
Correct.
Now, what that person said, we can agree that you don't remember what the exact words were.
I don't remember the exact words, but I remember the message, yes.
Okay. And the message had to do with something to the effect of either turn your phone off or put it away.
Correct.
Now, you characterized that, or in your own mind, you thought that it was rude, right?
It was very rude, yes.
But you can agree with me, you also thought that, in a way, that it was kind of to the fact that it was just matter of fact in the way it was said.
It felt demanding and like an order, yes.
Well, but you also agree that it also sounded just matter of fact,
Correct.
right?
Yes.
Okay.
It wasn't a friendly ask, please, or do you mind? It was just turn your phone off or put that phone away. Very demanding and very, very abrupt.
Okay, but again, we can agree with this. I think that that was one interpretation, but you also saw it as being very matter of fact and not, for instance, kind of the way that you described it. So it was matter of fact.
I object. It's been asked and answered, now it's becoming argumentative because he didn't like the answer.
Well, Judge, I disagree. If we can just ask, let me just ask Ms. Olson one time just to clarify to see what the answer is. You agree with me that you considered it, in addition to the way you just described, as just matter of fact way of asking as well, right?
Yes, in addition to those other things, yes.
Thank you. Now, at that point, Mr. Olson is still facing forward, and he has his phone out, but we can agree you don't know where his phone is at that point.
Correct.
Now, Mr. Olson responds saying, and again, you don't remember the exact words, correct?
Just the message, but not the exact words, right?
Okay. Something to the effect of, what's your problem?
He's still facing forward, not giving any attention to the man, and he just kind of blows him off and says, "What's your problem? The movie hasn't even started yet.
And he
I'll
may
be
have
done
said,
shortly, I believe.
I'm sorry?
I'll be done shortly," or,
And something to the effect is, of the effect of, mind your own business.
That was the second part after Mr. Reeves had approached him again in that same mean and demanding manner, do it now or turn it off now.
Okay, so Mr. Olson says, "What is your problem?" And he follows it up by saying, after what you said, "I mind your own business."
Right. There
And-
was
and-
contact by Mr. Reeves in between the two statements, yes.
And Mr. Olson said it in an annoyed tone.
I feel like he was just blowing him off, yes.
But Mr. Olson was annoyed.
That would be my assumption, yes.
He sounded annoyed to you.
To me, yes.
And the response to that annoyed response was by Mr. Reeves, "Do I need to go get a manager?" Is that what you remember?
Yes.
Okay. Now, you agree with me that Mr. Reeves' voice was not loud at that point.
Not loud, no. Let me clarify. In a movie theater, to me, a whisper is appropriate. So it was not a whisper, it was probably talking in a normal conversation.
Well, but you agree it wasn't loud.
Correct. It was not yelling or screaming, yes.
Okay. It was loud enough conversational tone so that one person can communicate to another person, right?
Correct,
And the other person could hear the person that's communicating.
right. Same as Chad's voice, yes.
Except it didn't sound annoyed like Chad's voice. We can agree with that.
No, it sounded angry and rude and demanding.
Okay? And how did it sound angry if it wasn't loud?
Just the whole demeanor that he's in our space, most people would ask politely, would you mind turning your phone off? It wasn't like that. His whole demeanor, the whole presence, the whole tone, everything about it just did not sound friendly.
Okay. It wasn't loud. We agree with that.
I agree with that.
Mr. Reeves certainly didn't curse.
No,
You said he got in your space, but you never turned around at that point, correct?
I had mentioned that I did glance out of my peripheral vision and see him, but no, I did not turn and specifically look to see more details or features of him.
Right, and we can agree, I'm looking at you, but peripherally I can see the clerk if the clerk moves around. So
Right.
that's what we're talking about here, right?
Okay, correct.
Okay. And again, Mr. Olson said something to the effect of, "Do what you need to do."
Correct.
And we agree in terms of the exact words in that conversation, you don't remember the exact words.
No, there could be a very slight difference of words, but the meaning was exactly the same.
Well, okay, but you know how words are and meanings, people can listen to a word and hear a different meaning, so it's important that when I ask you if you remember the exact words, if you do and if you don't, please let us know. So we can agree, at least in that conversation, that in terms of the exact words, you can't say what they were.
Right, and when I say, just to clarify, just so we're clear, do what you need to do, or you can do what you need to do. We're talking that slight of a difference, but yes,
Okay.
they're not exact.
And that's what you mean by something
Yeah.
to the effect of.
Right.
It's the impression kind of that you get.
Right.
Right?
Okay.
Okay. Now, at this point, you don't notice any curse words or any foul language?
I do not know.
Now, at some point, Mr. Reeves leaves the theater, is that correct?
That's correct.
Okay. But you don't actually see him walk down his aisle, correct?
No, you sense him and you feel his presence, but I did not actually see him until he was on the stairwell.
Okay, well, let's talk about that. Mr. Reeves didn't touch you.
No,
He didn't touch your seat.
no,
He didn't lean over the top of you,
not at that time, no.
okay? He didn't lean over the top. We're talking about when he's leaving the theater to speak to management. He didn't lean over you at that time, right?
Correct.
Okay. He doesn't yell or blow in your hair or anything like that?
No,
Okay. And so, and again, I'm just trying to say presence, so it's kind of an intuition, a feeling you're getting. You can feel him, but you don't see him.
right, I feel he's angry, and you just sense that. You just are aware of it because you're there and you've experienced what has happened before that. So you're aware that he's standing up and that he's there.
All right. So you don't see him, right?
not at that time.
You don't see him stand up.
Right.
You don't hear him say anything, right? At that point.
Right.
He doesn't touch you or your seat, right?
No.
And, but somehow you feel his presence get up. Is that correct?
Yes.
Do I have that right?
You hear it, you sense it, yes.
Okay. Well, now you're saying you hear it. What did you hear?
Well, you hear movement. Yes, I can't recall I heard a specific thing, but you just sense it.
Okay. Was there something on the movie screen playing?
I'm sure there was.
Okay. And again, you don't recall what was playing,
No.
right?
No.
And so you feel the presence of Mr. Reeves get up. And again, you don't see him walking down the aisle. The first time you actually see him is when he's on the steps going down,
Correct.
right? So again, do you sense his presence walking down the aisle as well?
I would think I knew what he was doing, yes.
Okay. So now you sense his presence walking down his row, I should say. And then as he goes down the stair, again, that would be your peripheral vision that kicks in.
Right.
Okay. And we can agree that Mr. Reeves is not making any kind of stomping noises that you can hear on the stairs.
Not that I could hear, no.
He's not walking down rapidly or, kind of running down the stairs, that sort of thing.
Not running, no.
Pardon me?
Not running, no.
Okay. And not walking rapidly.
It seemed like a normal walk to me, like a normal person would do.
Okay. Now, at some point, Mr. Reeves comes back in the theater, correct?
Correct. And just so we're clear, you said out of my peripheral, I did actually turn and watch him go down the stairs. It wasn't just in my peripheral, I did watch him, yeah.
Right. And I appreciate that.
Okay.
And so let me back up a little bit. You're sitting there, and so peripherally, you can see this movement on the stairs, and then you turn, and then you watch Mr.
I
Reeves
did
walk
look,
down the
yeah,
stairs.
I did look,
Is that fair to say?
yes.
Okay. And so then you have a good look at Mr. Reeves, and to you, he walks normally down the stairs like a normal person would.
Correct.
Now, Mr. Reeves at some point comes back to the movie theater, correct?
Correct.
Now, at that point, Mr. Olson is no longer using his phone.
That's
Is
correct.
that what you recall?
Yes, it,
And Mr. Reeves says something to Mr. Olson.
that's correct.
Okay. And what do you remember Mr. Reeves saying to Mr. Olson?
To the effect of, you've put your phone away now, I see.
Okay. And so, again, not the exact words.
Right.
Um,
I'm
and-
sorry. I see you've put your phone away now that I went to get management.
Okay. But again, in terms of the exact words,
Right.
you cannot be sure.
Right.
And again, Mr. Reeves isn't yelling at Mr. Olson.
No?
Okay. Again, his voice is in a normal speaking voice.
Yes.
We can agree with that. What's the next thing that happens?
I remember feeling this should have been over. He's got what he wanted. Why is he still doing the, ha-ha, you did what I told you, I won? That's kind of how it felt to me.
All right, but
Is-
again, let's talk about that, and we'll get to where you want to go. Mr. Reeves never said, ha-ha.
No,
Okay. Again, that's what you sensed.
that was my feeling, yes, is that was his intent of saying what he said was not a polite, oh, thank you for putting it away now, we're all good. It was to keep nagging at Chad, to keep the argument going,
Okay,
is how
and
I
again-
felt.
All right, and again, this is what you're speculating what was in Mr. Reeves' mind. We can agree with that, correct?
It was my interpretation of it, yes.
Okay, but again, you don't know what was in his mind.
No,
Okay, and you're kind of using your intuitive powers or your powers of understanding presence of people to kind of tell us what you're feeling about that. These are your feelings that we're talking about now, right?
yes.
Okay. Now, what's the very next thing that happens?
So we're to the point where Reeves makes his comments, and that's where Chad mentions, again, what is your problem? He said something to the effect of, I was checking on a message from my daughter. And during that, sometime during, as the conversation he was having, he stood up and turned around to face Mr. Reeves.
Okay, and we can agree that Mr. Olson stood up quickly and turned around.
Yeah, the chair pops up, so you have to be careful, to allow the chair to kind of come up behind your legs and your butt. But yes, he stood up.
Okay. In fact, it happened, in your mind, everything happened very quickly at that point.
Yes, I agree.
Including your husband getting up, Mr. Olson getting up.
Stood up like anybody would stand up to go and get popcorn, stand up to leave the theater. He stood up like anybody normally would.
But in this case, he's standing up to turn around and confront Mr. Reeves, correct?
Yes.
Now, at some point, Mr. Olson says something to the extent of, "What's your problem?" or something to that effect, correct?
Correct.
Again, we don't know what the exact words were, right?
Pretty close to that, yes.
And at that point, Mr. Olson's pretty angry, right?
Mad, angry, yes, and I would have to clarify. I think we can all agree that you can be angry, not like something and mumble something up under your breath, and then there's the other extreme of being angry or mad where you're exploding and you're having road rage. And so I want to make sure it's clear that my intent of when I say he was angry, yeah, he was probably frustrated. He was probably a little upset that this guy continued on and on and on.
Well, he was
And didn't appear to
angry,
be stopping.
he was angry and mad and saying, "What's your problem?"
Right,
And as he's doing that, this is happening either while he's standing up, right? Or on the way up. You're not sure exactly when
Right.
it happened,
right.
because it happens pretty quickly.
Yeah.
Now, tell me what happens next.
Well, I noticed Chad stand up, and it drew my attention. I thought, this is so silly at this point that it's gotten to this point where these two men are going to start bickering and causing a commotion, drawing the attention of other patrons. And so at that point, that's when I started to stand up in order to tap Chad.
Okay. Now, we can agree that in your mind, that's when the shot happened, correct? As you start to stand up.
Right when I start to stand up,
And
yes.
so I can understand the sequence of events. Mr. Reeves says something, and we've already discussed what, to Mr. Olson. Mr. Olson is standing up, responding to Mr. Reeves.
Correct.
You very quickly are trying to maybe stop an argument,
I was
right?
trying to get his attention, yes.
Trying to get Mr. Olson's attention.
Right.
And what do you do to get his attention?
I go to tap him. So I reach out to tap him, just to try to, I'm not going to yell or scream at him. That's what I'm trying to avoid him from doing. So I guess my natural reaction would be to tap him.
Okay. And so you reach up to tap him, but you don't know whether you were standing or sitting.
I can tell you that I was in the process of getting out of my seat when I tapped him, but I was not, it happened so fast I didn't even get fully standing.
Okay. And so you don't see Mr. Olson at any point reach across the seat to Mr. Reeves, correct?
No, I did not.
All right. And you don't see Mr. Olson 7 seconds later reach again towards Mr. Reeves?
As far as giving time frames and suggesting 7 seconds, how can this witness possibly answer that? He can ask her how long it was, but for him to do that, that's improper.
Well, I think
And
he's
it's
right.
hard to- It's not in facts or in evidence.
Judge, I'm going to
It's
ask,
exact time.
I agree with Mr. Martin. I think that's a better question. So you don't see your husband reach over towards Mr. Reeves
No,
at any time?
no,
And you don't see your husband reach a second time over towards Mr. Reeves at any time?
no,
And you don't see your husband grab anything from Mr. Reeves?
no,
You don't see your husband pull his hand back?
no,
You don't see your husband's hand come forward again towards Mr. Reeves?
no.
In terms of a message from your daughter, you never received any message from your daughter?
I did not, no,
And Mr. Olson didn't, as far as you're aware?
no.
Now, when Mr. Olson stood up, as you described, we can agree that you don't remember hearing any profanity.
I do not know.
It's possible, but you don't remember. Is
It's
that fair?
possible, yes, and I will say that although we did not use profanity on a regular basis in our household, it would not be shocking or anything that would necessarily stand out to me as frightening or anything to draw my attention to it, but I did not hear it, no.
Okay. Because you've heard him curse before.
Yes.
Now, let me show you some images. And may I approach the clerk?
You may.
By that, I mean photographs and
Okay.
maybe some movies. This is composite exhibit number 26, and I'm going to show you JPEG 2060495. Before we get there, you know, that day, Mr. Olson had an iPhone,
Yes,
and he had it in a black case.
yes,
You know, it was a white phone in a black case. Right?
yes.
Okay. Now, let me show you this exhibit. Keep it right there, please, Mr. No, put it, yeah, that's fine. All right, do you know what we're looking at here?
Yes,
All right. And so, this area would be where Mr. and Mrs. Reeves are, right?
correct.
And this is the iPhone. Could you zoom in, Mr. Shaw, please, on the phone? All right, that's your husband's phone.
Appears to be.
Okay, could you zoom out, please? All right, let's go into this next row, please, Mr. Shaw. Row in front. All right, a little too close. Zoom out a little bit, please. Out. Okay, stop there, please. All right. Now, this is where you were seated, correct?
Yes,
And you recognize the tissues because you use tissues when you eat popcorn.
yes,
And this is where Mr. Olson was seated.
correct.
Now, we'll notice that this is a popcorn bag here to the left where you said you placed it,
Yes.
right? So that's consistent. We also see here the armrest isn't up, but it's down. You will agree with me on that?
Yes,
Now, let me show you exhibit number 13, if I could. Your Honor, this exhibit was in the form of, oh, this one's all right. This one's a disc. We have a duplicate of the disc. You have a problem with that? Go ahead. Do you want me to use the one here? I'll be happy to.
Which number is it, 13?
This is exhibit number, exhibit number 13. No, it's the 400% loop. And it's the true loop, it's just the same thing over and over again, not, a little bit back and forth. I know. And I know you've been sitting here for days, and I know you've seen these before, but I would just like to have you look at these again a little closer. So your testimony is that you never saw Mr. Olson reach over at any point,
Your
correct?
Honor, I
Correct.
object to his interpretation of what's seen on the video, and him implying that certain content of the video includes him reaching over. So I object to the former question and him testifying as to what he perceives on the video.
I didn't say that was on the video, Judge.
The content of the question is absolutely clear, Judge, so let's not split hairs. We know what he was saying.
It's a fair question.
Thank you. All right, so we can agree you never saw your husband reach over.
I did not.
Okay. I'd like to show you what's been marked as exhibit number 12. And these are the bitmaps, Glenn, that I had them downloaded because they take so long to load up. If you don't mind, just a
Of number 13?
of number 12.
No, number 12 is bitmaps of number 13.
Yes. The whole sequence, but we're going to show the second part. I think it's 697. Now, Mrs. Olson, I know these are tiny. I don't know if you can see what's going on there. If you want, with the court's permission, you can stand up and get closer. It's up to you, Mrs. Olson. If not, as we get to different images, I can blow them up.
As you ask your questions, if I need to get
I
closer.
appreciate it. Judge, may
do
we
that.
have Mrs. Olson step down?
If she wishes.
If I need to, depending on what his question is.
Okay, well, just let's take a look at it going
Okay.
through it, and then I might have some
Okay.
questions. Okay, if you would, please? Thank you. May I have you approach the witness? Thank you. Okay, go ahead. Oh, I'm sorry. Sorry, Glenn.
So we are doing this frame by frame, is that what I'm going to be seeing?
What you're going to see is, it is, but we're going to do it kind of in sequence so that you can see it.
Okay.
And we'll stop if necessary. Go ahead, please.
And I'm sorry, what point in time are we at when he's coming back from telling management or?
You'll see.
Okay.
Okay, thank you. And for the record, those are 79 to 731. The bitmap numbers of the individual images are from 697 through 731. Mr. Shaw reminded me. And again, your testimony is that you didn't see Mr. Olson at any point reach over towards Mr. Reeves
I did not.
a second time,
Not a first time, so definitely not a second time.
or bring his hand back, or put popcorn forward.
I think I've answered that now.
Okay. Give me one moment, please. May I, Judge? Thank you. I don't have anything else. Thank you, Judge.
Judge, if I could have a brief moment with Mr. Shaw before I begin my call.